Before the courtroom even settles, the atmosphere is already heavy with anticipation. This isn't just another routine hearing. It's the beginning of a legal unraveling where every word, every filing, and every admission could shift the entire direction of the case. The judge, the attorneys, and the defendants all step into this space carrying more than just legal arguments. They bring consequences, histories, and pressure that hangs over every second. What seems procedural at first glance is actually the opening of a far more complex legal confrontation where decisions made in minutes can alter lives permanently. The courtroom is quiet, but the tension is anything but calm.
Lori Anderson versus Armani Lyman.
Hi, Judge.
Hello, Miss Anderson.
I
All
want,
right.
on advice of counsel, I wanted to cancel this matter.
You want to dismiss it?
Yes, sir.
Case is dismissed without prejudice.
Thank you.
Thank you. That's it for that block. Yay, we're back on track. All right. Court calls case People versus Lewis McSwain.
Trovius Starr, standing in for the attorney of record, Mr. William Amadeo, on behalf of Mr. McSwain. Mr. McSwain, state your name.
Lewis McSwain. Okay, hands out here.
Your Honor, two things here. First, Mr. Amadeo has informed me that he has not received discovery yet, so he's asking for an adjournment. And then secondly, it's my understanding that there's a community corrections violation for positive for opioids.
And cocaine.
And cocaine. Okay.
So that you know, on April 10th, he was positive for cocaine and opiates.
That's what I first got out.
On the 17th, a week later, there's no drugs found, but he has diluted his creatinine. So he watered the test, and it comes back with diluted creatinine levels. But then by the 23rd, about 6 days later, the opiates are back.
That's correct, Your Honor. I think that for the 10th, the defendant had just gotten out of jail after being arrested, so there was nothing to indicate that use may have been while he was on bond. However, the court is absolutely correct about the 17th dilute creatinine as well as the 23rd with the positive opiates. I am aware that there's a prescription that Mr. Starr showed me for hydrocodone that's prescribed to the defendant. However, the date of that prescription that I saw on there, I mean, there's a new one, April 29th,
April 29th of
2026.
Your Honor, if I may, my client hasn't, well, Mr. Amadeo's client has informed me that he's been receiving the script that could approach for 2 months now. He can go back and show prior scripts. May I approach?
Yeah.
There's 3 different prescriptions on there.
Okay, I see that, but
The last one is for hydrocodone.
this is from the 29th.
Correct. He informed me that he can go back and get those prior scripts. A letter from his doctor as well to show that he's been receiving this now for 2 months. So the open.
You always get them filled at Walgreens?
Oh, Jesus. I'm sorry, what was the question?
Does he always get them filled at Walgreens?
So they're Walgreens. Other places.
This other place. A little closer.
It varies in terms of the place he picks up his prescription. He can get a letter from his doctor stating the initial date that he was prescribed hydrocodone.
Well, I think somebody better go find that because all I have in front of me is a positive test and a prescription after that date. I don't have anything on these indicating.
I didn't have no way. When I got out, I had already been taking them, so I don't keep this.
And it's interesting also to me that
This moment marks a turning point where facts begin stacking in a way that cannot be ignored. The discussion around drug testing results introduces a pattern: positive results, dilution concerns, and repeated substance indicators. In courtroom terms, patterns matter more than isolated incidents. Each test result becomes a data point in a larger narrative the court must evaluate. The mention of opiates and cocaine is not just procedural, it immediately elevates the severity of the hearing. What follows is no longer just about compliance. It becomes about credibility, control, and whether the defendant can safely remain within the community under supervision.
Well, let's see. Make sure that I'm saying this right. Which would be typical that these aren't refills.
I also think I noticed that, Your Honor.
So,
And it would be the request of the people just to make the record clear that the defendant be remanded at this point and his bond be revoked. This is his third task that he's given, and the two that would have been when he was on bond, neither of them are acceptable or negative. It's also my understanding when someone does an intake with community corrections, they're very understanding. They understand that people may prescribe things that will come up on their test, and I don't have an indication of what we let me know that the defendant had that conversation with community corrections. It's oftentimes the case that they will say to the effect of, we are aware this person is prescribed buprenorphine, we're aware that they're prescribed any variety of things that may be positive on the test. The court in this case, I don't know if you've had an opportunity to review the charging documents, but this is a delivery and manufacture case. Okay, so this is a case where we have somebody that's manufacturing or delivering controlled substances, and he's now testing positive for opiates. I'm extremely concerned and would request that his bond be revoked, he be remanded.
Your Honor, I'm asking at this time, just for right now, that you not do that. If you could allow me some time to possibly get in contact with his doctor so we can get this squared away. He has a prescription for hydrocodone. That's there. He's informed me.
prescription though is after the date of actually both of these. Oh, actually the first test and the after the date of all of his testing.
Yes, the prescription that we have right now. That's why I'm asking right now, just for this moment, right now, if you not do that to allow me to clear this all up. I was just informed about this. It's not my case.
So let me ask this.
And also, too, one more thing. He does not.
Okay, go ahead, interrupt me.
Okay, I'm sorry.
No, go ahead. What do you want to say?
My client has informed me that he does not have a supervisor, an agent at community corrections.
I bring him that and tell him. Because the warrant came out after I had.
What do you mean he doesn't have one?
He has no one that he goes and speaks with directly.
I pay my money and
So you can speak up. You can speak up.
I just pay my money and drop. But I was trying to bring it to anybody's attention, but they said they don't have nobody.
So I'm asking if you could pass this matter and allow me
Here's
to.
my question. Why does he have these today?
Because he's been trying to inform people that, hey, I'm taking these medications, and which one of them is an opioid. So he brought it to court. He did this instead of leaving it at home. He did the smart thing and brought it with him. Instead of
He had a positive test.
yes, because he's been taking opioids, and that's the part where I'm asking if we can pause this matter so I can look further into this, so I can shell this out.
What does Bellinger want to say?
Your Honor, I would so too ask that this matter get passed for a few moments. I do have some information that I can share with the attorney that may or may not be helpful to at least past use of Norcos. Fine.
I'm just asking if we can pass this matter for right now. I'm not even asking,
I want to know. Hey, certainly, Mr. Bellinger, I'll let you talk with counsel, but I'm trying to figure out why did he bring these today and not the previous ones?
Can I say something?
It's been my experience, Your Honor. Been doing this now for 11 years. I've come. Yes, wow. Congratulations, Joel. Yeah, thank you.
11 years.
I've come across plenty of clients who
Like
say, "Oh, I have
For the time that's like 1/20th of the time Vincent's.
I have a prescription," and then I ask, "Where's the prescription?" "Oh, I left it at home." He brought it with him. He's been trying to get someone to see, "Hey, I have a prescription for."
Here the courtroom enters a critical evidentiary conflict. Timing becomes everything. A prescription presented after a positive test creates immediate suspicion, regardless of intent. Judges do not evaluate just explanations, they evaluate alignment of timelines, documentation, and consistency. The attorney's argument introduces uncertainty, but uncertainty alone is rarely enough in a courtroom when records appear contradictory. The judge's concern is not emotional, it is structural. What matters is whether the evidence supports lawful use or suggests violation. And in this moment, that line becomes increasingly blurred, setting up a much more consequential decision ahead.
For these things. He hasn't been able to see anyone at community corrections to show them.
Where's the previous prescription?
That's why I want to look into. That's why I'm saying if we can pass this right now.
What I'm trying to figure out is why he didn't bring that one. Because this one is problematic because it's all after his testing.
No, I don't know.
Oh, you knew.
They tear their car, but I'm saying for the prior one, I know the one wasn't on. It wasn't on any papers.
Your Honor,
And none of the
answer your question.
Cocaine. But anyway, go ahead.
But that was, I believe, when he got released. But to answer your question, why did he bring this? Community corrections called them and informed them, hey, positive test. So he brought that. He brought the current prescription. Again, I've come across plenty of clients who say, I have a prescription. Where is it? I left it at home. I can't find it. He brought something. I'm asking based off of that something, if I can go and look further into it just for right now.
For how long?
10, 15 minutes.
Okay, then at this point, his bond's revoked. They can take him, and then we'll bring him back out if necessary.
Mayor,
If you want to, but I don't know if you do.
Previous prescription. I didn't have to keep because there wasn't a warrant out for my arrest for this case. So I had no reason to keep it. I wasn't reporting to anybody. So when the warrant came out, that's when I was normally, and now I got to start keeping them. But prior to that, I never had a warrant, so I never had to keep them.
Oh, okay. All right. Thank you. I don't know yet. I'm going to give him 50 what he's got to do. Court calls case versus Ashley Treat.
That's all people.
And Lori Yaki, Assistant Public Defender with and on behalf of Ms. Three, who's approaching. Ms. Three, could you say your name for the court? Absolutely. So, Your Honor, within the last couple days, Ms. Three has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. And I have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning. It's very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her sober link to a scram tether to ensure that she's getting 24/7 supervision monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
Yes, Your Honor. There's no minimizing. There's no excuse or justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses. So she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe. And you know,
So
again,
even worse, she had a 13-year-old blow into the machine?
well,
I didn't ask
So-
her
so-
to.
This moment is one of the most emotionally and legally explosive points in the entire hearing. The allegation that a child was involved in circumventing sobriety monitoring transforms the case instantly. It is no longer just about substance use, it becomes about judgment, responsibility, and the boundaries of supervision compliance. The courtroom tension intensifies because this type of violation carries implications far beyond legal technicalities. It speaks to decision-making under pressure and the extent of rule-breaking behavior while under court supervision. The judge's reaction reflects the seriousness of not just the violation itself, but the ethical shock embedded within it.
Whoa, 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 whoa. Is that what happened?
um,
Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it. Because I don't know which is worse. You telling me that yes, is that what I did, or you lying to me?
I, at this time, Your Honor, I'm asking if the court would convert her to a Stram tether and mandate that she
Drank and then had a child blow into the sober lane.
I understand that's what the violation report says, Your Honor. And
Does she admit to that violation or not? I mean, if she wants a hearing, we'll have a hearing.
I understand. May I have a moment to verify with her, Your Honor?
Yep.
Your Honor, may we briefly approach?
I don't know what good it's going to do, but you can come on. Record should reflect we've had a bad conference in this case. Just want to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the Ben's conference is if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient treatment program with the tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged defense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case held in jail without the opportunity to get inpatient treatment.
Ms. Feltes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is an operating while intoxicated third offense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers crashed, and when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that sober link. I do not think she is in a position where she's capable of making good decisions, and I do not think that she is a risk the community can tolerate. I'm asking both the bond holder of that bond to deny her release.
Anything else, Ms. Carter?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a scram, if she's in treatment, especially if she can't leave.
I can't trust her. I'm just going to be upfront. It is going to be very hard for me to trust somebody that this court releases on a sober link, can't comply with the sober link, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference May 14th, 2026, 9 a.m. I'll also adjourn since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the Washington County.
As the hearing reaches its conclusion, the prosecution firmly requests bond revocation, citing repeated violations, substance use while under supervision, and escalating noncompliance. The defense attempts to reframe the narrative through treatment, trauma history, and structured rehabilitation plans, but the court is ultimately tasked with a broader responsibility: community safety and risk management. The judge weighs all arguments, but the pattern presented throughout the hearing is difficult to ignore. Ultimately, the decision reflects the court's determination that supervision conditions have been violated to a degree that warrants remand and bond revocation.